Before you start your argument, you're Mr. Sorensen, is that correct? I pronounced that correct?
Yes, judges.
Okay,
Mr. Jayson Sorensen.
okay. And you are representing yourself?
Yes,
is that
sir,
correct?
pro se.
Okay, and I know you sat through this afternoon's docket and seen the procedure. Do you have any questions about anything that we need to talk about before you commence
I don't
your
believe so, Your Honor. I'd like to request 3 minutes for rebuttal.
3 minutes, all right. When you begin your argument, the green light will come on. Then as your time runs out, the yellow light, and then the red light once your time is out. So, but that, we're saving your 3 minutes of rebuttal time. No other questions?
No, Your Honor.
All right, then you can tell us whatever. Go ahead and introduce yourself, just for the record, and then we'll go from there.
May it please the court, honorable judges. I am Jayson Roy Sorensen, appearing pro se as the appellant in Sorensen v. Sorensen. Although this marks my inaugural appearance before the appellate tribunal, I approach this moment with profound respect for the judicial process and gratitude for the court's indulgence in hearing my plea for justice. This appeal emerges from the ashes of a contested divorce in the Montgomery County court system, where systematic oversights and discretionary missteps have not only upended the legal framework governing marital dissolution, but have also inflicted deep, enduring wounds upon a family already strained by years of military service and sacrifice. At the heart of this matter lies the dissolution of my union with the appellee and mother, Monica D. Sorensen, forged amid my nearly 23 years of service in the United States Army, service punctuated by 17 combat deployments that demanded I place duty above domestic presence, leaving indelible marks on our 2 young children, Harper and Everett, now ages 10 and 7. The trial court's rulings on divorce grounds, evidentiary review, judicial recusal, military retirement protections, asset division, child custody, and support obligations have not merely erred in law, they have eroded the very pillars of equity and fairness that this court safeguards, exacerbating the emotional toll on a veteran grappling with 100% VA disability and on children yearning for stability amid parental discord. In my brief, I articulated 7 pivotal issues warranting reversal of the trial court's memorandum opinion in final order on August 1st, 2024, and its denial of my motion to reconsider or set aside on September 20th, 2024. I implore this court to grant me a divorce on grounds of appellee's inappropriate marital conduct, to mandate joint custody reflective of our children's best interests, to equitably redistribute marital assets and debts under Tennessee law, to recalibrate child support and arrearages in harmony with my military retirement and our mediation accords, and to affirm compliance with the Uniformed Services Former Spouses Protection Act, USFSPA. Should remand prove necessary to rectify these injustices, I beseech the court to so order, restoring balance to a narrative marred by procedural inequities. To illuminate a path forward, permit me a concise recitation of the factual and procedural landscape. Our marital unraveling commenced in 2021, when mutual agreement to divorce faltered upon revelations of the appellee's extramarital entanglements, affairs corroborated by her own testimony, her mother's testimony, and my own. Yet the trial—
We don't have a transcript of evidence, do we?
No, you do not, Your Honor.
And we don't have a statement of evidence, do we?
No, Your Honor.
So what we have is what pleadings have been filed in the trial court.
That is correct.
As well as the memorandum of opinion or the trial court's decision that's evidenced by way of memorandum of opinion. Is that correct?
That's correct, Your Honor.
Okay.
But I would not lie to you. I'm sorry. So the trial court inexplicably awarded her divorce on allegations of my misconduct, unsupported by the record, and represented intermittently by 2 counsel before I proceeded pro se. I navigated mediation under duress. The appellee withheld our children's visitation for 3 weeks prior, concealed financial disclosures, and later flaunted contractual agreements by refusing to refinance her vehicle or the marital home as prescribed in the mediation agreement, or to permit retrieval of my personal belongings within. Her inconsistent income declarations inflated pendant light support to approximately $2,300 monthly, while the Poly was depleting our modest savings exceeding $10,000, and additionally, she diverted funds through personal accounts and persisted in personal expenditures from our joint resources post-separation. My retirement from the Army in October 2020, burdened by full VA disability, has rendered sustained employment elusive, evidenced by fruitless stints at Oak Grove Racing, Gaming, and Hotels as a security manager for 1 year, and Maxim Healthcare at Amazon as a safety officer for 6 months, alongside a 2021 Social Security disability application. Yet the trial court imputed an additional $50,000 in annual income to me. Disregarding these realities, procedurally, my March 2023 recusal motion, grounded in perceived bias, was summarily.
Did you ever actually file a motion to recuse?
Yes. I submitted a letter, the motion to recuse, to the judge, and my lawyer advised me to, as a courtesy, give it to her to review and do that before it was submitted, and then I did submit the recusal, and then she did recuse herself eventually.
No actual motion to recuse was ever filed, correct?
No, Your Honor.
Okay.
Which only happened post-final order amid my contempt petition backed by variable evidence. The judge actually self-recused on March 20th, 2025, after this appeal's initiation.
Let me ask you a question. I'm
Yes, sir.
looking at the judge's findings in the memorandum of opinion, and we're talking about your employment here, okay? And I'm looking at paragraph 13 of the order. It says, the court finds it's appropriate to impute income to husband due to his failure to maintain gainful employment despite an ability to do so. Following his retirement, husband was able to earn $50,000 annually. While he testified his employment was detrimental to his health, he's since gotten sober and acknowledged there's no medical reason he cannot work. Did you introduce any evidence as to why you could not be gainfully employed?
I did not seek a professional psychiatric evaluation or something along those lines.
Okay. Any doctor's affidavits or anything? Obviously, you've got your disability status from the service, but anything other than that?
No, Your Honor.
Okay.
With my motion to reconsider on September 3rd, 2024, I've fortified it with 17 exhibits, but it was met with denial without substantive review. And September 20th, 2024, there's a hearing on my retirement division, devolved into judicial exasperation over case duration, which was chastising me and my current counsel despite comparable timelines in her docket. These lapses manifest abuse of discretion, culminating in excessive arrearages and tax allocations, contravening the USFSPA. Turning to the substantive grievances, the trial court's denial of divorce on grounds of appeals of inappropriate male conduct under Tennessee Code annotated 36-4-10111 stands as profound miscarriage, compelling trial evidence, testimonies unveiling her affairs, yet demanded recognition, yet the court inverted fault, abuse of discretion akin to reverse of John J. Hassabin v. Catherine J. Hassabin, where unsupported attributions of misconduct compelled appellate intervention. This error not only discourses legal accountability, but inflicts emotional devastation. Compounding this, violations of Tennessee Rules of Civil Procedure 52.02 and 60.002 permeate the proceedings. The appellant's recurrent inconsistencies on income, bordering on perjury under 39-16-702, skewed support calculations, denying due process in a manner this court has scrutinized for abuse, as in State of Tennessee, ex-rel Andrea Gutierrez and Lane Baggett. My motion's 17 exhibits unexamined could have reshaped the outcomes. The recusal saga further undermines confidence in the process, flouting Tennessee Supreme Court Rule 10 Bravo and constituting abuse under Rule 5201.01 which denied in 2023, despite bias indicators, the judge's belated March 2025 recusal, post-appeal, and contempt filing suggest impropriety, further depriving us of the judge stating her results after the final hearing and contested divorce rule per Rule 6.032 in thwarting confrontation of the appellee's discrepancies. Such timing erodes the impartiality essential to justice, as noted in recusal precedents, emphasizing reasonable doubt of neutrality. Federally, the trial court's handling of my military retirement breaches the USFSPA 10 U.S. Code 1408, awarding over $23,000 in arrearages from the time of separation, even through pendant light was ordered, nearly depleted the equity I was to be awarded in the marital residence and custody was decided without regard for my deployment's impact on caregiving or recalculations of child support. This overreach, abusing discretion under Rule 52.01, ignores protections from service members, exhausting assets and denying funds from marital refinancing, a harsh penalty for one who sacrificed health and home for country, especially considering the appellee's extramarital relationship while I was away from military duty. The inequitable division under Tennessee Code 36-4-121 amplifies this injustice. The appellee retained our home amid her unaddressed mediation breaches, savings depletion, and misuse of my post 9/11 GI Bill benefits, contradicted her testimony on graduation and contributions. Ignoring my military contributions, this allocation defies equity and rectified in appellate reviews of marital property disparities. Finally, custody of the support rulings contravene Tennessee Code 36-6-106's best interest factors and 36-7-107's military parent protections. 4 separate requests were made for a GAL, and when denied, a request for the judge to talk to our daughter in chambers was made twice, yet denied. My proposed joint parenting plan attuned to our children's needs for dual involvement yielded the primary designation for the appellee, burdening me with all transportation despite disability and financial hardship placed on me with imputed income. Imputing an additional $50,000 income ignores my VA disability status, contradicting evidence of the familial bonds vital for young hearts navigating divorce's turmoil. Collectively, these transgressions reveal an abuse of discretion, evidentiary neglect, and legal misapplications that have scarred me emotionally and financially while jeopardizing our children's future. In summation, honorable judges, the trial court's multitude of errors had not only flaunted statutory mandates, but has shattered the human essence of justice. I acknowledge my 2022 DUI messed up in separations, early throws, yet I transcended it through introspection and commitment to work towards exemplary fatherhood, only to face rebuke for candor while the appellee's inconsistencies escape scrutiny, as my exhibits attest. As a retired veteran, I have battled for fairness here as fiercely as broad, and am imploring this court to reverse these rulings. In doing so, you affirm not just law, but the passion that mends fractured families.
Thank you. You still got your rebuttal time. Hear from the appellee.
Good afternoon, Stacey Turner from the Montgomery County Bar, representing the appellee Monica Sorensen, and I represented Ms. Sorensen at the divorce trial of this matter. One thing that's very important for the court to understand is after we filed this divorce in January of 2022, there were some temporary motions, but we mediated this case on December 14th of 2022 and resolved everything except for attorney's fees, and the grounds for divorce, the parenting plan and child support, and any retroactive for the military retirement. The military retirement was resolved in the mediation, and it kept being brought up at the trial of this matter even though it was resolved, and both parties at different times during the pendency of this divorce had filed motions to enforce the mediated agreement, and the court, in its order of March 17th of 2023, enforced it. And also reiterated that any retroactive payment of the military retirement that he was not paying at the time was going to be considered at the final hearing. So that issue, when we did get to trial, also the first time we got to trial, or first time it was set for trial on January 9th of 2023, Mr. Sorensen did not appear. I think that is in the court's memorandum. After the court issued an order that day for him to come in for drug and alcohol testing on the day of trial, when he did not appear, he tested both positive for THC as well as alcohol on that day. That was one incident that occurred during the pendency of the trial of this matter. Another incident that occurred during the pendency of the trial of this matter was a DUI that Mr. Sorensen received during his parenting time with the children. The children were not in the car, granted, but it was during his parenting time. That video of the stop and Mr. Sorensen's behavior while he was intoxicated on both alcohol and gabapentin was evident, and the court considered that, as well as the multiple findings of fact in its 16-page opinion with under paragraph 4A through M, the court went through the various incidents throughout the 8-year marriage of significant alcohol abuse, which not only affected the parties' marriage, but it affected Mr. Sorensen's ability to parent the children, and why she determined that Ms. Sorensen was the primary residential parent and not Mr. Sorensen. That was one of the reasons in the factors that she went through under 36-6106 in determining that my client should be the primary residential parent. Another incident or another factor that the court considered greatly, and it's reiterated throughout her extensive written opinion, is the conflict between Mr. Sorensen and Ms. Sorensen was evident not only in the courtroom that was witnessed by everyone, but writings that were introduced as evidence where Mr. Sorensen threatened to have the recordings pulled from the divorce trial and shown to the daughter later on in life if she didn't, later on in the daughter's life if she didn't agree to a 50-50 plan. The times where he declined to exercise his court-ordered parenting time because he had other things to do, and during his court-ordered parenting time, the mother was not to schedule any extracurricular activities, not to schedule any doctor's appointments, that he would not take the children to those, that was her job. He would not feed or do homework on his time when he had the afternoons during the week, because that was her job. She would have to do that when she got the children back at 7 p.m. It was that kind of communication between the parties that was very concerning to the court. He would not allow my client to park in his driveway. She had to park across the street to retrieve the children. That was brought up in court, and that's why all the exchanges now are at my client's home for the children because of that conflict. The court felt that Mr. Sorensen had significant alcohol as well as anger issues that prevented him from being an equal parent. The court laid them out in its extensive opinion, and we do not think that that should be overturned. Mr. Sorensen, he mentioned the recusal. There was not a Rule 10b motion filed. His lawyer filed a letter with the court when we filed our motions to enforce the mediated agreement, and in open court it was brought up. In that order from March 17th of 2023, the court said, I will not sua sponte, recuse myself. You need to file a 10b motion, and I will take it under consideration. No 10b motion was ever filed, and the court did not recuse itself during the pendency of this matter. I do not know why, after this went up and a new petition was filed by Mr. Sorensen, the court recused herself. I have my assumptions, but I will not speculate on that. But the court has now recused itself, and Mr. Sorensen has filed a new petition to modify. We're in court on that now. With regard to the other issues that Mr. Sorensen raised, his income issues, that was one of the big things for the court. The testimony was that after Mr. Sorensen retired from the military in October of 2020, he was working at Oak Grove Gaming Casino as security there, earning $50,000 a year. He testified he voluntarily quit that job, and then he went to Amazon. My client testified that Mr. Sorensen told her that he was fired there for suspicion of drinking. Mr. Sorensen testified at trial that that was not true, that he voluntarily quit that job. I asked him extensively about his ability to be employed. He talked about things he was doing. He talked about doing landscaping work, doing renovation work on his girlfriend's house and his girlfriend's son's house in Knoxville. That he was also staying home to care for his girlfriend's young child and homeschool her. That one of his reasons for not working was he didn't want to work for the man. That was included in the judge's written opinion. I asked him about his Social Security disability claim. He said that was denied. He does have 100% VA disability. I have lots of clients who do, and work a DOD job in addition to that. I don't think there's any doubt that Mr. Sorensen is able to be gainfully employed, and his work history affirms and supports.
What's the evidence in the record about that?
Evidence in the record about what, sir?
Well, you've got a 100% disability.
Yes, VA
Military
disability.
disability.
Yes.
And we don't have a record. We've got pleadings. We've got the court's order.
Yes.
So I'm trying to determine how to review the imputation of income based upon that.
Well, the court lays it out in paragraph 12. You read some of paragraph 13, but paragraph 12 as well, saying, yes, you have VA disability, but that does not mean you're 100% disabled from working. As, we're a military town. I represent lots of clients who have 100% VA disability and have a $100,000 DOD job as well as DFAS retirement. So that disability in and of itself does not mean you can't work. What was relevant to the court was that he did apply for Social Security disability, which has a different standard about whether you're able to work, and he was denied on that, as well as him testifying that he had this prior job history, he quit those jobs voluntarily, and he was doing physical labor on a continuous basis, and he testified that he was not able to work, that he was just choosing not to work because he didn't want to work for the man. I think those things support the judge's ruling that he's voluntarily underemployed as outlined by the definition in the child support guidelines. I think those are all the issues that he's raised. Do you all have any questions of me?
See none.
Thank you.
Thank you. I believe you have 3 minutes of rebuttal, sir.
Your Honors. First, I'd like to bring up the ability to work issue, which is the last issue that Ms. Turner brought up. I did try working 2 different career fields. I was a pilot in the military and a mechanic in the military. For 18 months, I worked right after retirement. I was then imputed the $50,000. So if I did get another job, I could make up to that, and it wouldn't change my child support to Ms. Sorensen, in my understanding, because I would be earning money, but I'm already imputed that income. So for the past 3 years, I have chosen not to work so that I can focus on my mental health, staying clean and sober, maximizing the time that I do have with my children. I get them on for 3 hours every Tuesday and Thursday, and then every other weekend for 48 hours. So if I had a job, I probably would have to forego my Tuesday and Wednesday visitations, so that would impact my quality of life and my children's time with me as a father. But in essence, I could get some type of part-time job and make a little bit more money, so that I would have a little bit more money to spend with the children, spend on the children per se. But my experience with the civilian workforce compared to my military service was very drastic, and it impacted me from having to go from a certain type of structure to kind of a lack thereof in a whole new environment, and it wore down on me. And at the end of that 18 months of employment with the casino and Amazon, that culminated at the same time as the impending divorce that happened. And since the divorce proceedings started, my mental health has been getting better, I believe, because I'm not working. If I was working and going through these divorce proceedings for the past 3+ years, I believe that my mental health would be detriment, and it would, and also to my children's benefit of the type of father that they'd have. And as for working for the man, that was probably just a misstep of wording when I was under oath. I thank you for you guys' time. I really appreciate it today.
Thank you, thank you. Appreciate your briefing, your argument, both of you, and we will take this matter under advisement and attempt to render an opinion as early as possible. You may be excused.
Thank you, Your Honor.
Ms. Ashley, you may recess court until the call of the docket in the morning.